Are we all set?
Yes, sir.
Mr. Sprague, do you wish to record the proceedings?
Go ahead, Derek, you can answer.
Yes.
Are you requesting my permission to do that?
Requesting permission to exercise my right, yes.
I will allow you to record the proceedings. Just a rule that you have to ask permission, and thank you for doing that. I will grant it. Let's go on the record. This is the State of Wisconsin versus Derek Sprague, case number 21 CF 353. The state appears by Assistant District Attorney Kelly Hayes. Mr. Sprague is here in person. He is with his counsel, Gerald Purcell. This is the date and time scheduled for a preliminary hearing. It is also noticed as available on hearing today. Let's deal with the preliminary hearing first. Mr. Purcell, does your client still wish to exercise his right to have that hearing?
He does, Your Honor. Thank you.
You're welcome. Is the state ready to proceed?
Yes, Your Honor.
You may call your first witness.
State calls Daniel Dooley.
You do solemnly swear that the testimony you shall give in the matter now on hearing shall be the whole truth, so help you God.
I do.
Go ahead when you're ready, Ms. Hayes.
Good afternoon. Can you please state your full name and spell your last name for the record?
Daniel J. Dooley, D-U-L-E-Y.
What do you do for a living?
I'm a captain with the Antigo Police Department,
How long have you been with the Antigo Police Department?
over 23 years.
As part of your role as captain, are you familiar with the records and files kept by the Antigo Police Department?
Yes, I am.
And are you aware of a response by Officer Bruce Brown on October 19th of 2021?
Yes, I am.
What was that regarding?
Officer Brown responded to the school with social services to take a complaint from a child victim that was born May 2nd of 2005. The child victim had stated that he was at his grandparents' house initially. He was having a bad day, and his grandfather took him to the defendant Derek Sprague's residence here in the city of Antigo, Lake County, Wisconsin.
If you saw Mr. Sprague, would you recognize him?
Yes, I would.
Do you see him in the courtroom today?
I do.
Can you describe where he's seated and an article of clothing he's wearing?
He's seated at the defense table to the right of the defense attorney, and he's wearing a black jacket.
May the record reflect the identification.
It will so reflect.
When did the child victim state this had occurred?
Sometime over the weekend of October 15th to the 17th, 2021.
And what occurred at that residence in the city of Antigo?
The child victim had gone to lay down in a bed, in a bunk bed, and at some point the defendant, his father, came in and pulled him off the bed, at which time his arm got scratched.
Did the defendant do anything else to the child victim?
The victim also stated that the defendant then punched him in the face, causing a bloody nose.
Thank you. I have no further questions.
Cross-examination, Mr. Herschel.
Officer, first question, are you personally familiar with any of the facts in this case?
I reviewed the criminal complaint.
Were you personally involved in any of the investigation?
I was not.
Okay. And I would assume that means that you did not speak to Matthew, the child in the case?
I did not.
Okay. In your review of whatever reports and records you looked at in preparation for today's hearing, I guess let me ask you first of all, what did you look at?
I reviewed the criminal complaint.
Any other documents at all?
No.
So your testimony is based on what's contained in the four corners of the criminal complaint, is that correct?
That would be correct.
Are you aware of whether the child stated specifically what day these allegations took place on?
Just that it was sometime the weekend between the 15th and 17th of October 2021.
Are you aware of whether the child said there was anything that led up to these allegations happening?
Nothing other than having a bad day at his grandparents to start with.
So it's your understanding that just out of the blue, Mr. Sprague pulled him out of the bed and then punched him?
Yeah, that's what I know.
Okay. And there wasn't anything stated about whether the child was misbehaving, whether they were roughhousing, whether they were goofing off, anything like that?
Nothing that I'm aware of.
Okay. I don't remember if it was in the criminal complaint, but I saw somewhere that the officer who was investigating did not see any injuries to the child. Is that correct?
I don't remember that being noted.
Okay. I think the child at one point said he had a bloody nose, but the officer said he didn't see that.
That's possible.
Okay. And are you aware of any reason the child would have for saying something like this against his father?
Objection outside the scope of a preliminary hearing and seeking for discovery.
Well, the issue today, of course, Mr. Herschel, is plausibility and not other possible options or explanations. If you're getting to an issue that might pertain to plausibility, I usually let you go down a little bit, but if it is just searching for discovery, you'll be provided with that in due course, and I'm not going to allow it for that purpose. So cut to the chase if you're going somewhere with that, please.
I will, Your Honor, and thank you for allowing that. Do you need me to rephrase the question, or do you remember it?
Rephrase it.
I believe it essentially I was asking if you're aware of whether the child had any reason to say that his father did these things to him, such as he was being disciplined, such as his father took something away from him, he was upset and angry with his father, anything like that?
I don't know.
Okay. And are you personally aware of whether anybody else may have had some reason for making the child say these things against Derek, such as retaliation?
I don't know.
Did the child, to your knowledge, give any specifics as to what time of the day this took place?
Not that I'm aware of.
And are you aware of any other details concerning the situation at all, such as where the punch supposedly took place?
Just that he was on the floor. The child victim was on the floor at the time.
Somewhere in Mr. Sprague's home?
Yes.
It's my understanding that the child was at his grandparents' prior to this situation happening. Is that your understanding?
Correct.
Would that be his paternal grandparents?
As far as I know.
Okay. And are you aware of the fact that apparently the child was misbehaving there and that's why he was taken to Mr. Sprague's home?
He was having a bad day. Yes.
Okay, and specifically, it's indicated that his grandfather said that he was misbehaving and couldn't control him, I believe, and then took him to his father's home.
Correct.
Are you personally aware of whether the child was acting out or causing problems or misbehaving?
I do not.
Your Honor, given the nature of preliminary examination, that's all the questions I have.
Any redirect, Ms. Hayes?
No, Your Honor.
You may step down, Captain Dooley. Any other witnesses, Ms. Hayes?
No, Your Honor. This time the state rests.
Does the defense wish to call any witnesses today, Mr. Herschel?
We do not, Your Honor. We would reserve any rights to argument, so nothing further.
Well, so will you be contesting bind over today?
No, sir.
All right, then I won't make the parties give any final summation or argument today. I have heard testimony of hearsay variety alleging a child claiming that his father pulled him off of a bed and caused him to have a scratch on his arm, and that his father subsequently punched him in the nose or face while he was on the ground, causing him to have a nosebleed. I don't know a lot of other details or circumstances, but there is a hypothesis consistent with those facts that could be the basis for a charge of felony child abuse. So I am finding that the state has established probable cause to believe that the defendant has committed the felony offense that was charged in the complaint in count 1, and inviting this case over for further proceedings, including the filing of information. Does the state need time to make final charging decisions, or did the state want to file information today?
Your Honor, I just e-filed information while you were issuing your decision. It tracks the criminal complaint. Email a copy of that to Attorney Herschel if you'd like to view it. You can pull it up on my computer as well.
Did you want to have some time to review that and proceed to arraignment today or at a later date, Mr. Herschel?
Your Honor, based on the representations from counsel that it mirrors the criminal complaint, we are ready to proceed with the arraignment today. My client does understand the charges that are set forth in what was the criminal complaint and will be in the information, as well as his constitutional rights. Preserving all rights and jurisdictional objections, we would enter a plea of not guilty to all 3 counts.
All right, I think I heard you say you waived the reading of the information?
Yes, Your Honor.
All right, then the court will receive the defendant's pleas of not guilty to all charges contained in the information and direct the clerk to enter those pleas into the record. Attorney Herschel will address bond to if you want to today. What did you want to schedule next, though, besides that trial, motion hearing, status conference, something else?
Status conference, Your Honor, at this point.
Recommended date for that, Ms. Hayes?
April 11th at 11 a.m.
1 second here, let me check my calendar. Does Mr. Sprague have to be there, Your Honor?
He will not be required to attend. He's welcome to if he wishes. And you may appear by phone or Zoom if you wish.
I can do that then, Your Honor.
All right, so April 11th at 11, I hope counsel will be discussing this case prior to that date and have already agreed on a course of action from there and won't need to appear at all on April 11th if they've already started to work on scheduling whatever else comes next. But if nothing else is scheduled prior to April 11th, then I will talk to both counsel on that date and find out where we need to go next. And as I indicated, Mr. Sprague is welcome to be there, but not required to be there. Did you want to address bond today, Mr. Herschel?
I do, Your Honor. Mr. Sprague was ordered to post $300 cash when we had his initial appearance. We would ask that the court convert that to a signature bond. To the best of my knowledge and understanding, and I believe this is very accurate, Mr. Sprague has made all of his prior court appearances. His appearance in court has never been an issue. He is employed. He's been employed at Northern Wire for over a year now, so he has steady employment. Unfortunately, he's a little bit worried about losing his employment because of pending court hearings. It's taken a bit of a toll on him, but he does have gainful employment and is in good standing there. He does own his home here in Antigo, and he's been a resident of the area for at least 13 years and has family in the area. I do not believe that he's a flight risk, Your Honor. He has retained counsel at his own personal expense, and he will make his prior court hearings. He's very vested in these proceedings and wants to see them through to the end.
All valid reasons to consider a different bond. Ms. Hayes, do you wish to be heard on the issue of bond?
I do, Your Honor. The state is objecting to any modification of the bond here. I will note the state's recommendation was actually originally $1,000 cash bond, given the nature of the charges for the felony child abuse charge and 2 separate bail jumpings, as Mr. Sprague had misdemeanor bonds in 2 different counties at the time of this offense. Given the increase in penalty, the behavior itself, and the fact that he was already out on bond during this offense, I think that a $300 cash bond is already as low as it should be at this point.
All right. It is your motion. I'll let you have the last word if you want to respond to that, Mr. Herschel.
Thank you. Mr. Sprague also indicates to me he wants to ask that the conditions of absolute sobriety be lifted from that as well. We think that's onerous as far as his personal life is concerned. I would add to this that he is not having any contact with Matthew. There is a pending CHIPS case. So obviously protection is one of the issues that we have to consider when setting conditions of bond and bail, but Mr. Sprague has demonstrated that he will appear here at court hearings in the future, and I think that is the most important factor in determining whether cash is required to assure a defendant's appearance in the future, and he is here. He's going to continue to be here, Your Honor, and I think the court knows Mr. Sprague from other situations, and he's always appeared in court for those matters as well. Thank you, sir.
Well, both sides make valid points. $300 cash bond and a felony charge is relatively modest. Mr. Sprague has already been able to post it and has posted it, so it's not a problem being able to do that. He's gainfully employed. I know his family. I think I saw his mom in posting that, or maybe he's paid her back with her money, but I don't know that they're a wealthy family, but they're certainly a family that is employed, has some financial means, and he's hired an attorney. He's not indicated any financial hardship that has been caused by having to post the $300 cash. If his attorney were here saying, I'm gonna be off the case unless I can get some money freed up to help me, that would be a consideration. Mr. Herschel makes valid points. I've known Mr. Sprague for a long time, since I think, probably since Matthew was born. Maybe even before that, known his family. I'm sorry for the loss of his father. I've known his family for a long time. He is local. He does own real estate here. He does have a history of missing court one time because he got defaulted on a traffic ticket or something. He wasn't required to be here, and we went through a motion hearing. I'm trying to reopen that. I can't remember how that ended up, but that was not a required court date that he missed. That was apparently a mix-up on the time or the date or something, as I recall. But yes, I've seen him in my court many times. I'm not really worried that he's gonna run away and hide from this. But I also don't think there's really any good reason to return it, to refund it. It's out, it's there, it's posted. I'll be happy to grant. Did the state think that alcohol was alleged to have anything to do with the alleged charges?
Yes, Your Honor. And
Is that noted in the complaint?
It is not, however, it's not required to be noted in the complaint. I will note for the court that his other open pending Langley County case did very clearly state that alcohol and a bar was at issue. The original bond in his CM file did also include the absolute sobriety and advanced establishment filling Class B liquor license. The state, of course, modified that after a period of time at Mr. Sprague's request. Given that there's two cases that both involve that, I think that that's an appropriate condition of this one.
I want more information on this case. It's not in the complaint. Share with me what the reason is that it's needed.
The child victim reported that once he had returned to his father's house that weekend, one of the things they did was go to a bar for food, and that this occurred right after returning home from that bar.
And dad drinking?
I don't remember specifically if that was mentioned or not, Your Honor.
Your Honor, I don't have access to discovery yet, but I do have the CHIPS petition that was filed, and nowhere in there am I aware of any concerns being raised that alcohol was involved in this. Mr. Sprague indicates to me that he was stone sober. There was not alcohol involved in this incident at all.
All right. I've heard enough. I'm not satisfied. It would be wise, and I'm sure you'll talk to your client about that, to abstain from use of alcohol while he's out on bond, because there is probably no good that can come from it. As my dad told me in life, I never liked that I drank at all. But I'm not satisfied that the alcohol was a factor in this case. So I'm leaving it as a $300 cash bond, but I will eliminate. There was 3 conditions. No presence in establishments with a Class B liquor license, no use of alcohol or maintain absolute sobriety, and also required him to cooperate with Department of Health and Social Services. He's got a pending contested CHIPS case, so I think we know the spirit and intent of that, but I'm not sure I'm comfortable with that one either. On there, I would recommend, to the extent he's willing to, that he do that, but if he's got a dispute with them, I'm not going to require him to do whatever thing the county Health and Social Services asks him to do. It may have some impact on access to his child if he chooses not to cooperate with them, but we keep it at a $300 cash bond with just the standard bond conditions, no additional provisions. Anything else to take up today, Mr. Herschel?
Not from our side, Your Honor. Thank you.
Ms. Hayes?
No, Your Honor.
We are adjourned.